Monsieur Michael Buenger. À vous la parole, monsieur. À vous la parole.
Thank you, esteemed moderator, honored guests, and participants. My name is Mike Buenger, and I am the Administrative Director of the Supreme Court of Ohio. My task this morning, very briefly, is to explain to you admission to the practice of law and the judiciary in the United States. I do want to congratulate our moderator for keeping us on time. I do not envy a task of trying to keep a group of lawyers and judges to 7 minutes, so congratulations. For comparative purposes, I thought I would begin briefly by explaining an important constitutional provision in the United States, and that is the separation of the federal government and the state governments. Because the states existed before the founding of our current federal government, they retain many of the police powers or the general powers of the nation, and that extends to the licensing of lawyers and the selection of judges for our state courts. For perspective, we have approximately 800 federal judges in the United States. We have approximately 18,000 state judges in the United States. The United States state courts process approximately 100 million cases a year, compared to roughly about 3 million cases with the federal judiciary. The reason that's important is because, as I said, the licensing of lawyers is a matter of state prerogative. I am, for example, a member of the Ohio Bar Association and the Missouri Bar Association. That gives me permission to practice in the courts of Ohio and Missouri. I cannot practice in the courts of Kentucky or New York or California unless I receive special permission of that state's Supreme Court. And because the state Supreme Courts regulate the bar, they have significant influence in terms of legal education as well. The state Supreme Courts are responsible not simply for admission to the bar, they are also responsible for continuing legal education requirements, and they oversee the disciplinary system for all of the attorneys that are licensed within their states. That's important to understand because we have 50 different attorney regulation systems in the United States. There is no national bar as you might find in other countries. Even for me as a member of the United States Supreme Court bar, I had to be licensed first and foremost before the bar of a high state court, in my case, Ohio and Missouri. In terms of entering the legal profession, our legal education is a post-undergraduate process. It is equally easily for an engineer, a teacher, a political scientist, even a medical doctor to go to law school. There is no requirement in undergraduate education to actually study the law. You can do this at any time after you have received your baccalaureate degree. In my case, I have a baccalaureate degree in history. I taught high school for 4 years and then went on to law school to complete my legal studies. Once I complete legal studies, I have to sit for a state bar exam. And because, again, there are 50 regulatory systems in the United States, each state Supreme Court gets to set its admission requirements. This includes not only its bar exam, but it also includes the regulation of character and fitness requirements. I have to meet, if I want to practice in another state, the requirements of that state's Supreme Court in order to do so. I can, on occasion, apply for special permission if I am representing, for example, litigants before another state. But other than that, I have no general right to practice in a state to which I have not been admitted to the bar. The United States draws its judges from its practicing bar. You do not go to law school with the intent of becoming a judge, or you may go to law school with the intent of becoming a judge, but that doesn't guarantee that you will. And much of our legal education in the United States is focused on what we call case-related education. We are a common law nation. And even in the courses that we take concerning statutory law, much of our education is framed by reading what the courts have said about the application of statutory law to specific facts and circumstances. Therefore, a lot of our legal education is on judicial analysis, on judicial procedure, on judicial arguments, on advocacy. because, as I said, the courts of the United States, as a common law nation, in fact set the law of the United States through the practice of precedents. Our judges, as a system of recognition as opposed to career, are drawn from our practicing bar. They must meet certain requirements, each of which are set by the state Supreme Courts. In Ohio, before a person can be considered for judicial office, they must have been a practicing member of the Ohio bar for a minimum of 6 years. Other states have set different standards. For example, in the state of Florida, you have to be a practicing lawyer for 5 to 10 years, depending on what judicial office you are seeking. And we place a premium on continuing education. Almost every state in the United States requires its lawyers and its judges to engage in constant, continuing legal or constant judicial education. In most states, it's 40 hours every 2 years. In our state of Ohio, judges must complete 40 hours, 20 of which must be specifically on judiciary-related issues. We call them CJE or continuing judicial education requirements. A lawyer who fails to meet their continuing legal education requirements is suspended from the practice of law until they come into compliance. And since judges must be licensed members of the bar in order to sit in judicial office, a judge who fails to complete their education, their continuing education requirements, is likewise suspended from judicial office by a function of the Supreme Court suspending their license to practice law. There are multiple other topics that could be addressed in this forum, including the very odd practice in the United States of electing its judges, which is unique in all the world. As I mentioned, of the 18,000 state judges, the vast majority of them stand for some type of democratic election or oversight. That principle was anchored in the 1840s in the belief that corrupt legislators having too much influence over the selection of judges would lead to a corrupt judiciary. As a result of that, most state constitutions provide for direct election, either through what we call retention election or through direct competitive elections. And the terms of office for judges vary. In Ohio, for example, every judge must stand for election every 6 years. Other states have various time frames by which their judges are also subjected to some kind of democratic accountability directly to the people. That is an odd feature, and I believe we are one of only 3 nations on the planet that elect their judges. I hope I've given you something of an overview of how judicial education and judicial selection work in the United States. I look forward to talking to some of you after this conference because I know time is of the essence. Thank you very much.
Thank you very much.